I remember the first tip that she gave me, early days for taking depositions, and it was a tough case. And she sat me down and said, okay, so this attorney you're going up against, he can be real tough. And so you need to have, a strategy. It's like, great. Tell me the strategy. And she says, well, when he starts objecting and kind of getting real aggressive and yelling, you got to lean back and you got to slowly take off your jacket. Okay. And then what do I say then? She's like, no. You just got to, wear something and.
Oh, okay.
And so that was the strategy, was to use what you have as a young woman to distract the older male attorney so that he wouldn't be so mean.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm excited to share this conversation with Shaana Rahman. Shaana is an accomplished trial lawyer in all facets. She is known for excellence in public entity liability, to the extent that a major municipality offered her a job in an effort to avoid her laser-like litigation focus, as well as helping cyclists. That cycling help withstood media scrutiny recently when she helped a family navigate the loss of their son, an international track cycling champion, when he was struck and killed by a drunk driver. Shaana has also devoted herself to mentoring law students and new lawyers, including founding the Trial Advocacy Diversity Fellowship through the San Francisco Trial Lawyers Association, and helping improve the diversity pipeline for what remains an overwhelmingly white, male, and hetero plaintiffs bar. In between all this, she got a hobby, running an olive farm with an award-winning olive oil, along with a not-insignificant TikTok following. So please, sit back and enjoy this interview with the talented and inspirational Shaana Rahman. Welcome to the show, Shaana.
Thank you, Miles. Happy to be here.
Are you really happy to be here?
I am thrilled. I was waiting for the call, for the nod to be on your show. And so I'm happy to be here.
One of the things I've always enjoyed about our conversations is that you never have any sarcasm in any of your communications.
That's how we bond, right? Because we don't believe in sarcasm.
Not one bit.
Yes.
I want to start where I normally do with folks, which is what got you into the law in the first place.
This is like a kind of a funny story. I think you're a parent, and so maybe you've done this with your kids. Your kids ask you a lot of questions, and sometimes you don't, maybe not 100% thoughtful about the answer. So you give them some answer that may be based on a piece of truth, not thinking it would affect the rest of their lives. Fair, you've done this?
I rarely provide a truthful answer, and I expect that they will need lots of therapy.
Okay, so that's kind of how I got my start in the law when I was very young. So not to give away my age, but my first recollection of a president was Jimmy Carter.
This was your first voting president? Or?
You're funny.
Okay.
So as a kid, Jimmy Carter, my mother was a liberal hippie artist, and she very much believed Jimmy Carter was a man of the people and was going to change the world for people. She wasn't right about a lot of things over the course of her life. There you go. And then Geraldine Ferraro being the first woman vice president, that was the time. And it was very exciting for me as a young girl. And I thought I might want to be in politics, and nothing about my life or where I was or how I'd grown up would give any indication that I could ever aspire to something like that, right? Given the circumstances we lived in. So I asked my mom, how could I be in politics? And she said, absolutely. How do I do that? She's like, oh, you have to be a lawyer. And that was it. The rest of my growing up years was all focused on how to become a lawyer.
Wow. You found yourself in a different slot than politician. How did you find yourself down this particular track?
I don't think, and this is not to disparage what we do, right? As personal injury lawyers, We face a lot of hurdles in terms of public perception, I think, with some good reason behind that, I think. So I don't think there are a lot of young people who go to law school with the idea that I'm going to be a personal injury lawyer someday.
I would agree.
Right. And so that's not where I got my start. I went to law school thinking that I was going to get some white shoe job in a corporate law firm. I was not, I was a kid who grew up in rough circumstances, and I believed in civil justice, but I also desperately wanted to fight my way out of poverty, And so I thought that's how people did it. You worked for a corporate law firm.
You fight your way out of poverty by working for the organizations that put people in poverty.
Right.
Okay.
But in my 20s, I didn't really give it the full circle analysis, right? My goal was single-minded. It was, I don't want to end up where I came from.
That makes a lot of sense.
Yeah, it did at the time. But in order to put myself through law school, I had to work. And the job that I got was working for a gentleman who did workers' compensation law. And he represented mostly longshoremen. And it was not anything that I understood or had thought about, but it was working day to day with men and women who had really tough jobs. But these were really good jobs. They were well paying. They had benefits. People wanted them. They wanted to keep them. But these folks they got hurt. And when they got hurt badly.
This in the Bay Area?
So that's what I did during law school. I represented longshore men and women. And I really got a taste for, the human condition and what it meant for me to be able to help them navigate this system that was complicated and to make sure they were fairly treated. And it turned me.
Expanding on that a little bit in terms of how you got that position, it was this, on-campus interview, summer clerkship, wine and dine, or was this a job that you found some other way?
I remember doing on-campus interviews and all those things that we did where we wrote letters on the typewriter. I think, was that what we were doing back then? And we sent them through the mail. I didn't have much success with on-campus interviews because I didn't know how to navigate these systems. They were so foreign to me. This job, I think, was a posting, in a binder in the campus administrator's office. They kept a binder of listings. It was one of those kinds of things. I had no end to it. I didn't know what the job was. It didn't pay much, but I got the job.
After law school, did you stay with that, or did you find yourself moving in a different direction?
I stayed there through the bar exam. And, I had thought that I would stay there because I'd been there for a number of years. But then I realized I didn't want to be pigeonholed into the workers' compensation system because it's somewhat limited. So I wanted to see other things. And I had done a stint also in law school. I got a grant or a fellowship where I worked for a public housing organization up in Sacramento. And I thought that also was something I'd be interested in helping people fight unfair housing and employment situations. And so I wanted to broaden my horizons. But the job market was terrible. And so I answered 2 ads for jobs, one as a plaintiff's attorney for a very well-known plaintiff's lawyer. And he turned me down. And the other one was for a small insurance defense firm in San Francisco. And I didn't know what insurance defense was. We didn't have Google, so I couldn't Google it. So I sort of got a loose understanding that it was working for insurance companies and defending people who hurt other people. And that was the job I got. It was a small firm called Hardiman and Carroll. The partners were, they had left Long and Levitt to start their own firm.
So people with some pretty decent chops.
They were great. In terms of, I think we look at insurance defense now as plaintiffs' lawyers. It was kind of a different business back then. These 2 guys, I couldn't have asked for better bosses or mentors. They were good lawyers. They were good people. And, they cared about their employees.
Roughly how long were you working that side of things?
I did that for about 5 years.
Can you tell us a little bit about some of the opportunities, the exposure that you were given as a 5-year lawyer? And it might be helpful for people to get a loose time frame of what we're talking about in terms of decades.
Well, this was at the end of the last century. Yeah, this was the late 90s. I started at this firm and downtown San Francisco. And I had some experience in a law firm. When I did work for the workers' comp guy, I had a lot of experience there. I got to do board hearings in front of the administrative law judges because you didn't have to have a law license to do that. I was negotiating settlements for clients. I was talking to insurance adjusters. So I had a broad base of experience. Tried my first case in front of a federal ALJ.
Wow.
Yeah.
And this is all before you were a sworn lawyer?
The first case I tried was I had gotten my ticket maybe weeks before and tried it was bench trial. My star witness, the orthopedic surgeon, his name was Dr. Butcher. And I will never forget that because, it's your first thing. And even though it's not a jury trial, it's a judge and there are people, it's comp. So there's 1,000 people in the tiny courtroom. It's chaos. And you have, a limited amount of time to put on your case. And Dr. Butcher gets up there with his file, and his file is probably paper file, 3 feet tall. And he balances it on the ledge of the witness box. And so what happens.
I can't guess.
So first thing, Dr. Butcher knocks over his file. And that's then where it go. That was my first trial. But it worked out. It was, a trial on a very discrete issue. We won. But that was my first taste. So that's the experience I rolled into this defense firm. And, they gave me 35 cases and said, let us know if you have any questions.
Wow. Did you have any sort of established mentoring, or was it a knock on the door, can I grab you for lunch?
It was that kind of informal thing. And there was one woman in particular who was probably like a 5 to 7 year associate, and she was kind of the person to go to, right? And she made herself available, and she had a lot of interesting tips. And I remember the first tip that she gave me. I was going into not my first deposition, but early days for taking depositions, and it was a tough case. And she sat me down and said, "Okay, so this attorney you're going up against he can be real tough, and so you need to have strategy." It's like, great. Tell me the strategy. And she says, well, when he starts objecting and kind of getting real aggressive and yelling, you got to lean back and you got to slowly take off your jacket. Okay, and then what do I say then? She's like, no. You just got to, wear something and...
Oh, okay.
And so that was the strategy, was to use what you have as a young woman to distract the older male attorney so that he wouldn't be so mean.
I like the idea of using all tools that are available at one's disposal to zealously advocate. It doesn't say great things about the legal profession that that's one of the tools that you were suggested to use in your arsenal at that day.
And, obviously this is 25 years ago now. And I think about that. I mean, I still remember that conversation I had with this woman, and coming right out of law school where, I did trial advocacy in law school. I did mock trial. I did all of those things. And it wasn't that far removed from what professors and instructors were telling young women in law school, right? The advice we were getting was you need to wear a blue, black, or dark gray suit, skirt suit. That was very clear that you shouldn't wear pants. You should wear nylons. And, this is not 1952. This is, the mid 90s. So getting that piece of advice from this other young lawyer was not as shocking as it sounds today, because it was sort of a continuation of what we had been told, in addition to a lot of discussion about how to behave as women.
Part of the reason I asked you earlier about the era that you were in as you're experiencing this is to help us kind of frame the conversation. And with that in mind, I'm interested in hearing what types of additional items were you as a young female lawyer being told you should or should not do?
So the time frame, I think, is almost a red herring for me.
That's not reassuring.
It's not, and it's something that I still I'm shocked at today, because I still see continuing education courses geared towards women that are titled something like "What to Wear to Trial." So I think in some respect, we still do that to women lawyers. I think it happens in the media. It happens, in our professional organizations. It happens, in small groups. We still constantly critique and discuss both what women wear, how they wear it, how they say things, how they behave. Are they aggressive? Are they shrill? All of those things, you still hear them. So I think that in the last quarter of a century, I'm saddened that we have not progressed as far as I had hoped we would.
I'm troubled by it just because it doesn't seem like that's where we should be in the field today.
And I have had a lot of conversations with young women lawyers recently. They give me hope. They seem to think that things have changed and they are continuing the fight for equity in our profession. There are some really amazing women who are doing this work, even in our local community. And it makes me hopeful. So if they see things are changing, they are moving the ball forward, that gives me some hope for the future. When I see it through my own lens, I think there's a bit of impatience on my part, right? The fight that I have fought, as many of my women colleagues have fought for all these years, I think we really thought we would we'd get it to zero by now,
As you were given opportunities with this first firm, were you sent out to trial?
I was. I tried, but the trials, I was constantly preparing for trials and traveling all up and down the state, mostly traveling. But none of the cases went to trial. I tried one legal malpractice case with one of my bosses, but the carriers back then would settle a lot of cases.
I want to step out of the chronologic discussion for a second to fast forward to now. And it seems sometimes we go through periods where carriers try more cases, settle more cases. Are you noticing any trends over the last few years in the cases that you're handling in either direction?
What I'm noticing a lot of is the trend towards more underinsured motorist case arbitrations.
Can you expand on that?
I'm not sure if this is an anomaly of the cases I'm drawing just by happenstance, but I think in the last probably 5 or 6 years, more and more people are driving around either with inadequate insurance or no insurance at all. And I have, some theories of why that has occurred. One of those things is I think more people are buying their insurance on the internet. So without the benefit of a broker or an agent. And I think that's created a real problem. I see a lot of folks who have, who have assets and good jobs, who have things to protect, but are buying very low limit policies without underinsured motorist coverage or uninsured motorist coverage. And that suggests sort of a lack of knowledge or lack of help in procuring insurance.
In that vein, and this is an interesting rabbit hole to go down, when you have the situation where you run into someone who has inadequate insurance, and well, I'll lay out a not uncommon scenario. Someone has bought a $15,000 to $50,000 inexpensive policy. They have caused a significant injury. Your client has, say, $100,000 in terms of the UIM, which leaves a differential of anywhere from 50 to 85 in terms of what that non-stacking in California policy will cover. And the driver that you're dealing with has assets. How do you handle those cases? And I know I'm speaking very globally, and they vary from case to case. There are some lawyers, this is way too long a question, but I'll keep going with it.
Is this a question? Because
this is my monologue. There are some lawyers who are very averse to personal contribution. There are some lawyers who will do it under certain circumstances, and there are some lawyers who will always go after personal. Do you have a tendency or a trend or a litmus test on how you handle those scenarios?
Up to the last 5 or 6 years, typically, I was not seeing cases where people who had insufficient insurance coverage had assets attachable or assets with which to contribute. Yeah, but now that I am seeing it, it's a joint discussion with my clients. If my client doesn't want to do that or feels that that's wrong for them, then I won't do it. But I always advise my client that's part of a strategy. And I found more and more of my clients are willing to do it because they feel it's unfair, right? And so I've been pursuing personal contributions, and not just trivial amounts of money.
On that side, when you're handling that kind of a case, are you finding that you're able to resolve those cases early on in the process because the exposure is pretty straightforward and it's best that they get out? Or are you having to, go to the mat, go to trial sometimes because the defendant has the benefit of what is in essence free counsel?
I've been resolving them pre-litigation. It's a strategy that I try to design early on. And there are pressure points in that negotiation, right? You have the pressure point with the carrier and their duties to their insured. You have the pressure point with the defendant directly. And what I try to do is I try to arm myself with all information early on. Because when you get into this conversation with the first line adjuster or with the panel counsel they first assign for this potentially over the limits issue, they'll tell you things like, "Oh, my guy doesn't have anything. He's got, there's nothing here." And then if that in that conversation, you can read off a paper and say, "Well, what about the property at 122 Brown Street that he has X amount of equity in?" When you hear that pause, you've done the right thing. So strategically, you have to uncover that information to start the conversation, because that is the real pressure point. When you know the information the defense counsel either hasn't bothered to figure out or knows is just trying to play fast and loose with it, that's how you build it.
And when you're building that playbook on the pre-litigation side, are you doing these types of negotiations with information solely from what you've assembled from your own asset analysis? Or are you requiring that they provide information either to you or to a mediator for in-camera review? How do you do your due diligence and feel satisfied in what can be an unsatisfying scenario to find out that you have all the information in terms of what they can afford?
I tackle it from a variety of angles. I do a standard asset declaration, which is a little bit substantive and asks questions that Some people don't want to answer. And I find you can get a lot of information from, the things people don't want to talk about.
The declaration that comes back with 3 blanks on it.
Sure. Or refuse to answer on grounds of privacy and all those things. And that's people's rights. It's fine. So I start there to see what you get. I also do take advantage of internet resources. I do a deep dive myself because I think it's important to try to explore all the avenues. I try to find familial links so I can see if there are trusts or properties in family members' names and what is out there. And maybe not just the obvious attachable things, but things that possibly could create wealth for that person or an ability to put together funds. And then I use an investigator as well to kind of check my work.
When you're engaging in this kind of pre-litigation negotiation, is it all one-on-one with the adjuster or panel counsel to use a mediator for any of this kind of work?
I don't usually engage a mediator. I did one recently where we had a very short mediation because counsel was reluctant to disclose certain things about his client's mental condition. He was worried about the attorney-client privilege, so he divulged that information through a mediator, and we did it that way. But generally speaking, it's just one-on-one with counsel. Panel counsel or oftentimes personal counsel.
Outside of your pre-litigation cases, in the litigation world, do you use mediation on a regular basis?
I do mediate cases. It is not my preferred method for resolving disputes.
One of the things that has come up in conversation with various folks who've come in has been our failure as a profession to maintain the art of being able to speak with opposing counsel about the pros and cons of a case and to do the types of negotiating that used to happen before the advent of ADR. How do you feel about that?
Well, I remember the actual advent of ADR, which I think was sort of my first year of practice when the court sort of mandated referrals out to ADR. Well, at that time, it was a lot of non-binding arbitration and court-sponsored mediation. And people were really excited that was going to be helpful. And back then I was a defense attorney, and so it was helpful in the sense that if we as the defense attorneys with the money wanted to resolve a case and we got an opportunity mandated by the court to do that, cases could get resolved. I think that's very much changed because ADR, like everything that happens when you have something that becomes a must versus a shall, became a very, very big industry. And the more people who became mediators, the more marketing there was that in order to resolve a case and do your due diligence, you had to use mediation and resolve your dispute in that forum. And so I think mediation became a crutch for a lot of lawyers, right? It was sort of an easy out. And the more we mediated, the less we relied on personal relationships in a lot of senses. But, you and I are the generation where personal relationships were the key to moving your cases, picking up the phone, having lunch with opposing counsel, side conversations in a deposition. Those are all important pieces. And even before COVID, I found that less people wanted to make those efforts. The younger generation of lawyers, that was not their style of communication in a lot of senses. That's not what they were being taught. And then with COVID and being isolated and not having those personal opportunities to have those chats, and to get to know each other on the other side of the table, it has made all of that a lot harder.
Have you found any steps that have worked for you post Zoom Depo world to be able to to maintain connections or develop connections with opposing counsel?
I still behave the exact same way as always, right? I haven't let that stop me in terms of, I haven't augmented the way I do business, essentially. But instead of, going out for a cup of coffee, I pick up the phone. I have every defense counsel has my cell phone. We text, we talk on the phone for the counsel who want to engage in that way. And if they don't, I just try to be persistent until we get there. That's the only way I know to create some sort of relationship in this world where we're not seeing each other as much.
Join us next week for part 2 with Shaana Rahman. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.